Hello friends, myself Mohit and I am going to dictate you Steno legal matter. Please subscribe my channel and press the bell icon for more dictations. So be ready for the dictation. 5, 4, 3, 2, 1, start.
Admittedly, the Act is a social legislation enacted for the benefit of persons with disabilities, and its provisions must be interpreted in order to fulfill its objective. Besides, it is a settled rule of interpretation that if the language of a statutory provision is unambiguous, it has to be interpreted according to the plain meaning of the said statutory provision. In the present case, the plain and unambiguous meaning of section 33 is that every appropriate government has to appoint a minimum of 3% vacancies in an establishment, out of which 1% each shall be reserved for persons suffering from blindness and low vision, persons suffering from hearing impairment, and persons suffering from locomotor disability or cerebral palsy. To illustrate, if there are 100 vacancies of 100 posts in an establishment, the establishment concerned will have to reserve a minimum of 3% for persons with disabilities, out of which at least 1% has to be reserved separately for each of the following disabilities: persons suffering from blindness or low vision, persons suffering from hearing impairment, and the persons suffering from locomotor disability or cerebral palsy. Appointment of one blind person against one vacancy reserved for him/her will be made against a vacancy in an identified post, for instance the post of peon, which is identified for him in Group D. Similarly, one hearing impaired will be appointed against one reserved vacancy for that category in the post of store attendant in Group D post. Likewise, one person suffering from locomotor disability or cerebral palsy will be appointed against the post of Farash. Group D post identified for that category of disability. It was argued on behalf of the Union of India with reference to the post of driver that since the said post is not suitable to be manned by a person suffering from blindness, the above interpretation of the section would be against the administrative exigencies. Such an argument is wholly misconceived. A given post may not be identified as suitable for one category of disability. The same could be identified as suitable for another category or categories of disability entitled to the benefit of reservation. In fact, the second part of the section has clarified this situation by providing that the number of vacancies equivalent to 1% for each of the aforementioned three categories will be filled up by the respective category by using vacancies in identified posts for each of them for the purposes of appointment. A reading of the impugned judgment of the High Court shows that 3% posts in each cadre dehors. The identification of the posts are to be reserved for persons with disability, with blindness or low vision, hearing impairment, and locomotor disability. We find that such view of the High Court is not the correct enunciation of the law. The 3% reservation is to be in an establishment and not in all cadres of an establishment, irrespective of the nature of job. A reading of the shows that posts have been satisfied.